Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue you may have. Hey, good evening, everybody. Welcome to the Buy and Hold Meetup. I'm Andy Fowler, and I'm here with Sean St. Clair. We are live from the Arizona Buy and Hold Real Estate Investor Meetup. That's taking place at the Scottsdale Area Association of Realtors. We are here once a month. It's always a good opportunity to come and market, to meet people that are and professionals that are in the industry, the real estate investor industry, and to come and learn something. And with us today, graciously again, having us here is Augie Panev, the host of the event. Augie, how are you today? Good to see you again. Sean, well, he's on mute. Let's
Oh,
put
okay.
that. Go
Oh,
ahead.
yeah. I'm
Yeah,
back.
there he
Back
is.
here. All right. Thanks for having
All
me
right.
again here. Thanks for helping us with the event. What you guys do with us, it's very gracious. Just to remind everybody, Sean and Andy are here between 4 and 5 every time we do the event, and they can answer your legal questions live and no charge. Just buy them a drink from the bar. That's it.
Yeah, that's all we require. No, we don't even.
Drinks free.
Yes, that's the minimum they can do.
Yeah, that is the minimum they could do.
But yeah, no, I really appreciate guys coming here, helping us with a lot of knowledge in situations that actually I do have a situation I want to talk to you about a little bit later. But let's remind why we're here. So every last Tuesday of the month, I do this event for buy and hold investors, people that want to buy rental properties, hold them, and make money that way. We don't sell anything specifically. It's pretty nice. Informal meeting, bar, food, networking, good questions and answers. And also, every time I invite some professionals to talk about some specific topics that help us as an investors improve our business. So that's the whole thing. Please come, bring friends. It's all free. We don't charge anything. So
I would imagine, Augie, since you've been hosting this event, that you've met. I mean, how many people have you met where you've either done business with or shared
oh my
referrals
God,
with
this
since
is
you've
so
done
great.
this?
We started about 20 people coming here. Now we are between 80 and 100 people every time. In over, I think the list grew up to over 1,000 people that have been over the last year and a little bit coming here. So it's a good opportunity specifically for me to meet a lot of people and introduce other people to each other to help them. So
Yeah. No, it's a great opportunity, and we try to always encourage everybody who's watching online. That's great. Be a part of it, ask questions, but the real way to you know get into the industry is finding people that are in the industry. And I can't tell you, just in the ones that I've been to, whether it be real estate investors, hard money lenders, you name the industry, it's an opportunity to find it. And that's such a big part of kind of making your way in this industry is your circle of friends and
exactly,
referrals.
if you come here with questions, you're gonna have the answer, and somebody knows the answer, or they know the person that knows the answer. So that's how we get it to it quicker versus just sitting and watching videos online. Yeah, you can learn a lot, but the networking, it's where it's really good money will come back. So
So I understand, Augie, you had a question for us.
we got a situation on a property we just purchased with our acquisition company. So this is what happened. We bought a property up in Prescott, single wide. And on the back, we had a really nice shed, that was a little plus on the purchasing that single wide trailer. And we close the deal. We're getting ready property to list it. And then we're getting a call from some company that's saying that they want to repossess the shed in the back.
Ah,
Turns out that the seller did not disclose that the shed was leased from the company on payments. So now we're getting calls that the company will come and pick up the shed and take it. So now I have question kind of a, can these guys, this company, okay, payments are not made to them. The shed is not paid off, but can they have legal right to come on my property and pick up the shed and take it?
well, it reminds me right away, Sean, of your legal update from a week ago about security agreements. And it sounds like that's what we're talking about. Is that what you think?
Yeah, so that's essentially what the issue is what type of rights does the owner of the shed that's been leased have under the agreement with the owner? Now, that would not, though, extend to you and your property. However, it probably does say that if payments aren't made under that lease, that they have a right to repossess the shed, similar to like repossessing a vehicle.
Okay.
So you have the ability to repossess. However, the rule is on repossession, you're not allowed to trespass or disturb the peace. So the proper way for them to repossess, if it's on somebody else's property, which it now is, would be to basically file an action for either what's called replevin or repossession, which basically says, hey, look, I have a right to possess this property, this shed. It's on somebody else's land. So, judge, give me an order. And they would name, I'm assuming you have an LLC that owns the
Yes.
property. So they would name the LLC as a defendant. They would serve the LLC, and you would have an opportunity to defend and respond and say why they're wrong. But assuming they prevail, then the court enters basically a judgment that says, yes, the sheriff of the county, presumably Maricopa County, the sheriff of the county has the right to access the property with the owner of the shed and remove the shed from the property. But it would have to be a court order. They couldn't just self-help.
Can just kind of come
Yeah,
and
self-help and
and-
pick it up. Yeah. But unfortunately, if it is leased and payments aren't being made, then the owner has that opportunity. Now, the seller may have some issues, concerns with liability and things like that for not having.
Is this
disclosed
a
that, but-
lengthy process or it's pretty quick?
Yeah. So time wise, if you serve a lawsuit in the state of Arizona and the action is pending here, then the defendant has 20 days to answer. If the defendant doesn't answer within 20 days, then you have to give another 10-day default notice, and it's 10 business days. So that's really like 2 weeks. You give a 10-day notice. And then at that point, if there is no answer, then they have a right to apply for a default judgment and be put on the court's calendar, which could be 60 to 90 days from there. So all told, you're talking about like 90 to 120 days at its quickest. Now, if you defend or your LLC defends and answers and makes a defense, then it could take a year and a half to resolve it.
Okay.
So it's not a quick process.
Yeah, I'm trying to figure out, can I use that lengthy process, legal process, and negotiating with the company that leased it, so I can buy from them maybe
Yeah,
at
that's
a
something
discount.
you want to kind of pick offline and figure out, because you're technically not supposed to use the length of the court system, the
Oh, okay.
nature of the court system in order to leverage or negotiate a resolution, even though in reality that's what happens in most lawsuits. The time and cost and money results in the party settling it, but you're not supposed to use those things as leverage for settlement.
So eventually, with a court order, they can come and pick it up. Otherwise,
Yes.
right now, they cannot.
That's correct.
Gotcha.
It's really not any different than had you financed a vehicle and they have, the lender has a secured interest in the vehicle or the right to repossess it and go take it back.
Mhm.
The difference is, as Sean mentioned, because they can't breach the peace. In a vehicle, they can you take it to the grocery store and the repo man can find it in the grocery store and they can take it without breaching the peace. If it's an object that's on your property that requires them to trespass or do something else that they can't otherwise do, that's where they run into that.
Does the same thing
problem.
apply to solar panels? Kind of the same thing.
Yes, it would. But I will tell you about solar panels. They're scrap metal. Once they're off the roof, they're worth nothing.
They worth nothing.
So the likelihood that a solar company is ever going to repossess the solar panels, I mean, they're worth maybe
I
a
think
few
in,
$100.
in some cases, we've acquired properties through foreclosure auction
Yeah.
with solar panels, and I think at that point the lease is over, and we can request the company to come and pick up the solar panels.
Well, no, technically,
It's not
no.
it's not attached to the property.
Well, so it's what's called a fixture filing. So most solar companies will, most of them will do what's called a fixture filing, which means they basically say, "Hey, look, we have a lien against the personal property, which are the solar panels,
Mhm.
but those solar panels and the personal property is attached to the real estate." And so most of the time, UCC1 financing statements, which are the documents used to evidence liens against personal property, they're filed with the Secretary of State's office. However, when the personal property is being attached to real estate, you can then record the UCC1 with the Maricopa County Recorder's Office. And so it'll show that, hey, if anybody purchases this piece of real estate, please understand that these solar panels come subject to a lien in favor of the solar company.
What about during if it's a foreclosure process?
Oh,
Does it wipe out?
great question. So if it's a foreclosure process and the loan or the deed of trust was recorded prior to the fixture filing for the solar panels,
Which is most cases.
that it would wipe out the fixture filing, and likely result in the loss of that lien.
Okay, so yeah, that's pretty good. Then
Yeah.
we don't have to worry about solar panels when we buy the from the-
Correct.
Yeah, and the other area that you run into personal property issues, like the one you're dealing with the shed, don't see it as often with the shed.
That's the first. You know,
yeah.
hundreds of properties I've bought and sold. This is the first.
Where you do
It's a pretty nice shed.
okay.
It's with door, windows, porch. You know, it's probably around $11,000-$12,000 worth. You know, it's not like a shed to store some stuff, but you can actually turn it into a little guest house if you want.
Where you see it, where we probably see it more commonly because a major mistake was made is like a mobile home or a double wide or something like that, because that is personal property, and that is secured by a lien, a personal property lien pursuant to a security agreement. It's not until the property owner actually takes the step to file an affidavit or record an affidavit of a fixture to affix the double wide or the mobile home to the property for that to become real estate. So we've seen a lot of cases where
So
they've
this shed, I don't think shed can be affixed. But
No, it would have to be like a manufactured home. We do
Yeah.
have a Facebook user question here.
sure.
So they said, "Hey, but is the seller liable to the buyer for not disclosing?"
I think
The
so.
lease.
But what, you're gonna go and start, suing a old lady that just sold the property at a discount? It's just, I don't think it's worth it. You know, but I think she is right.
Yeah, I mean, the seller would have some liability there, but to your point, there's the liability versus practicality of it.
Exactly.
And is it worth pursuing? I don't know.
Well, and you're not talking. It doesn't sound like we're talking about a huge amount.
No, that's why we're debating what to do to negotiate to keep pay the balance for the shed, or just give it back. Which one is better for us? So we're not sure.
Well, and there may be a couple ways to negotiate that. One of the ways from your end is just negotiating the release of the lien. That doesn't mean that any negotiation with you is them agreeing to release the original lessor from liability
Yeah,
under
the-
that.
yeah.
So you could effectively negotiate with them a settlement just to release that lien and let it stay there, and then they retain their rights to go after the
So
original.
I keep the shed.
yeah,
Maybe settle at the discount price,
Right.
but they still can go after the
Yeah,
other person.
that's exactly right.
Okay.
Hey, Augie, we have another Facebook user question, and
Yeah.
I think actually you're a good one to ask because it's a little outside of my bailiwick as far as legal analysis goes. But so this Facebook user says that they're trying to acquire their first buy and hold. So this is you.
Oh, okay.
They're trying to
Good.
acquire their first buy and hold
Good.
in their local market. So they want guidance on underwriting and structuring the deal. Can you provide some guidance there?
Oh, do you have a couple hours? No, but so here's the trick.
Yeah.
With buy and hold, it's the long-term financing. It's very important, which means that you need to have a ready-to-go financing with a regular bank, 30-year fixed mortgage, because that's the most important thing for buying and holding the property. So you can hold it forever with a very good interest rate and set terms. As far as the acquisition, you should have private money loans ready to go. So we acquire the property at a discount with quick hard money loans, and then we refinance immediately as fast as we can with a long-term financing at a pretty good deal. So lately, because the rates have gone up, we've turned into more the creative side of the investing, seller carrybacks, agreement for sale, subject twos that provide us to take over the existing long-term mortgages that we can hold for a long time. But yeah, this is a trick. You need to have a long-term financing set somehow. Either you have to be bankable to be financeable, or you have to be able to acquire from the person you're buying it, take over the existing payments.
Now, on underwriting, though, help me out here, because buy and hold, there's frankly two uses, right? For the most part, there's long-term rental, right?
Actually,
Tell me.
we make from rental properties. We make money 5 ways.
Okay, talk to me.
All right, first way. First, the property eventually goes up in price.
Okay.
So when we do our underwriting, we do 3 to 5% increase in value of the property. This is historically. We don't go last few years we've had 10, 20. It's quite a bit, but we go 3% to 5% increase of the value of the property.
Is that any market or just
any market?
Okay.
This is very historic basic, and this is low.
Right.
Second, increase of rent. So when you buy the property on today's market, you rent it at, let's say, $1,500. But because rent is related to inflation, always goes up. So right now you'd be renting for $1,500, but in 5 years it could be at $2,000 per month. And your mortgage is fixed for 30 years. So your cash flow goes up. Even if the price doesn't go high or the cash flow doesn't be so great, the third thing we make money is at some point the mortgage will be paid off. So the tenant pays rent, rent pays the mortgage. So at some point, you're going to be able to have a free and clear property. The fourth way is taxes. It's a huge advantages to own rental properties. On rental properties, we don't pay taxes on the profit. There's so many advantages like 1031 exchange, step-up basis, depreciation of the property. There's so many things that you can use to offset your gains from cash flow from rent, or even move your losses from these properties into your ordinary income from your W-2 salary, for example. And the fifth way that nobody's talking about is inflation. Inflation is the hidden help for us, for the investors, because when we buy properties to buy and hold, we obtain long-term mortgages, long-term financing. And we borrow the money in today's dollar and we pay it later at cheaper dollar. So the inflation, it's eating up the debt. So that's how we borrow today. And later, if you borrow $1 million, if you had borrowed money in the beginning of 22, $1 million with 8-9% inflation, at the end of the year, it's not going to be $1 million. It's going to be 920,000. So that's how also we make money. These are the 5 ways we make money with rental properties.
Very cool. Yeah, that's great. Well, hopefully that answers the question that they were looking for. I think it more than answers. So that's awesome. Hey, I think buy and hold is the way to go.
So fix and flip and wholesale,
Right.
it's a job. It's good
Right.
income. You should do it. But if you want to be wealthy
Yeah.
and create a generational wealth, you have to hold properties. And when we buy and hold properties, we buy them with the intention never to sell them.
And you just be patient. You have to be patient.
Yes, and use the system and the structure that you already exists to move money around, refinance,
Right.
no pay taxes and things like that. So that it's a really, really good, safe investment.
Perfect. Well, go ahead.
Yeah, I was going to say, folks, you're getting a free mastermind here. You would never get this anywhere else. So ask your questions while you have it. Really appreciate your time, Augie. Thanks so much for being with us. We know it's going to be an awesome event. We know we have some other folks that are planning on asking some questions. Do we know what the topic is for next month?
Yes, next month I'm going to invite 2 professionals to talk about mortgage rates and for the statistics in the resale market. What I'm attempting to do is to do predictions for 2023, what the rates are going to do and where the market is going to be in the next 6 months. And then for April, we have another professional, a president of a large insurance company that will be here, giving us the inside scoop on how to pick insurance for renters insurance, landlord insurance, umbrella insurance, Airbnb insurance, all these little tricks on the back end that nobody knows. So he's going to teach us how to do it.
What about insurance for creative financing and subject twos? That is one of the biggest questions that I receive on a consistent basis is how do I structure my insurance for a property that I acquired subject to the existing loans?
Wasn't it? Don't you take over the existing insurance of the previous owner? You just get added to it?
I don't recommend it.
You don't
but some
recommend it?
people do it.
Okay.
Yeah, some people do it that way. My recommended way is for the new buyer, the new owner, to go and obtain insurance from their own insurance from their own broker, then names the seller slash borrower as an additional interest, and then names the mortgage company as the lost payee, and then the seller goes and cancels their insurance. That way, you don't have to deal with the seller being involved in any payout or anything like that if there's any type of loss or casualty for the property. So if your insurance person is coming, have them reach out to me and I'll talk to them and see if we can get them primed for that so that we can
Get the scoop.
get the scoop on that.
Okay.
Yeah, for sure.
We'll do that. So yeah, the next couple months that that's what we have coming.
Awesome.
Yeah.
Very cool.
Great. Well, appreciate it, Augie. And if you will, grab our next guest. If you're just joining us, everybody, we are here live at the Arizona Buy and Hold Real Estate Investor Meetup. It takes place live once a month at the Scottsdale Area Association of Realtors. I mentioned it earlier, and I'll mention again, if you're new to the show or just watching us, make sure to find us over at Facebook as well as YouTube. At YouTube, you can find us at INREM Podcast. That's at INREM Podcast. We'd like you to go there. Want you to click subscribe and like. That helps us immensely, and we would greatly appreciate it. With that, we have another guest who's here with us today at the Buy and Hold Meetup, and it is Paul, correct?
Farland.
Hi, Paul McFarland. Tell our listeners how you're involved in real estate and a little bit about yourself.
Sure. So I actually started my real estate journey back in New Jersey. I've been in the real estate industry for 20 years now. Initially got my real estate license. Selling houses was great, but needed that residual income coming in and got into residential and association management and have been there ever since. I've been in the Valley since November of 2006. Came out here for weather and opportunity and refused to go back east unless it's during the summertime.
All right. So what business are you currently working with now?
With ProX Realty Management, I'm the designated broker and owner. I work with Augie Panev, who was your previous guest. We currently manage over 80 doors throughout the valley. We do have one association that we're managing as well, so that keeps us very busy.
Oh, HOA association.
Commercial, so it's
Oh,
a commercial
commercial.
building, so same
Okay.
thing in terms of
Yeah.
enforcing bylaws and governing documents and what have you.
So previously, though, you did some association management.
I did. So back east at my peak, I was managing a portfolio of 14 different HOAs throughout New Jersey. Got into some on-site management as well. I've always kept my licenses and designations active with association management, just so I can properly advise my clients.
How do you think associations on the East Coast compare to associations here in Arizona?
So I would say the biggest thing is the complaints that come in. Out here, the majority of the complaints are going to be weed related.
Okay.
Back east, the majority of the complaints are going to be when you have to move cars to get the streets plowed. There's also weeds as well out there. So there's more problems on the East Coast, especially when you factor in freezing rain and snow with gutters being clogged with ice. It's just more problems out there for sure.
Interesting.
Yeah.
Is the regulation that the state imposes upon homeowners associations greater in a place like New Jersey than it is in Arizona?
I
Or
would
do you
say I would say it's about the same.
pretty similar?
Yeah, it's very similar. It's just the matter of enforcement and what's in their governing documents. Obviously, that varies per association.
So what's the landlord tenant management market like right now?
So the prices for the rental market has definitely stabilized. It definitely hasn't been increasing as aggressively as it has been in previous years. Now it makes more sense for investors to keep tenants in their property and doing small increases rather than going through the vacancy and having to rehab their properties. But in terms of pricing, it's definitely flattened out in the Phoenix metro area.
Oh, I see. So the prices that landlords can get was on the rise, but
Definitely on the rise.
you've seen it flatten out.
Definitely. Yeah.
Now, what kind of with your property management services, how do you guys structure your services in terms of you kind of you guys don't really do it a la carte, as I understand it. You kind of do everything for the property manager for a fee.
That's correct. So, if an investor comes to us and they have a vacant property that they need help filling the vacancy, the first thing we do is assess the condition of the home and give them the best feedback for what we think can provide them the best ROI. The main thing that we look to do is try and tenant proof properties as best as possible. So, rooms that have carpet, either put in vinyl plank or tiling. Paint, make sure we put in semi gloss in areas that can get easily wiped down. So, give them an assessment and also create that baseline for after that tenant moves into the home. When it's time for future upgrades, we have that baseline already established. So once we do find the property, have the conversation with the investor, we do all of our marketing and advertising and screening of tenants to find the best qualified tenant for the home. After that's done, then it's a matter of setting them up and the investor with our web-based application that they can access all of their reports online. And tenants can submit their work orders and payments and rinse repeat every month.
So for the landlord or investor, it's really just sign up and sit back and let it go.
Sign up, sit back. So yeah, the hardest part, if any, is at the beginning with them signing a lot of the documentation and disclosures that we have, as well as making sure that they're aware of what to expect over the next year while that tenant is in the property.
And now you guys are able to, and as I understand it, also handle all the back end stuff in the event that an eviction has to happen. and
That's
everything
correct.
else.
Yeah,
So
we have everything streamlined through our systems where there is a grace period that is established in all of our leases, and if a tenant does not make their payment by that grace period, then we start the eviction process, and everything is pretty streamlined out here where between getting the judgment to the writ of restitution for the eviction, it's typically about a 45-day process.
Yeah, well, and I know the eviction process in Arizona, and I imagine this would be the case in many states. It's it can be formulated, it can be notice laden. In other words, you have to do certain things in order to have certain rights to do it. And
That's
so
correct.
so often I've found that landlords that aren't using property managers forget to send out your 5-day notice
So true.
or things like that. And then
So
they get
true.
45 days down the road.
And they're behind the 8 ball.
And they're not any day closer than they were when they started.
Exactly right. And that's the main reason why I think it's important to for investors to either educate themselves or hire a property management company, because we do have that whole process streamlined. So there's no delays where, like you said, with the 5-day notice, if you don't have the certified receipt showing that it has been sent certified, you're essentially starting all over again.
So what kind of legal issues or legal questions have you run into that we might be able to help with?
So I was curious about prepayments for if a tenant makes a prepayment on rent, what is the eviction process for that?
Yeah, so when in dealing with rental payments, if a landlord, at least in Arizona, accepts a partial payment,
Mhm.
they waive their right to an eviction for that month. So in order to keep that right, in order to preserve that right, when that's happened, the landlord is in a position of having to tender back the rent.
Okay.
And depending on how the payment is made, will depend on how easy or not easy that can be. It's interesting. I'm sure that over time, landlords have gotten better at this, but the biggest, some of the hardest difficulties I've seen of this, because if in the old days, if a tenant paid a partial payment of rent,
Right.
it would come in an envelope, right? And there'd be a check, and you, the landlord or the property manager, would be like, "This is not correct."
Yeah.
And then maybe they'd ask their lawyer, whatever else, and they would send it back and say, "Sorry, we're only accepting full payment, right?
Yeah.
This is not acceptable," and you send it back. So tendering was easier to do.
Sure.
But in the area of like direct deposit, and so many landlords want that, right? They don't want to deal with a check.
Sure.
Now you find out after it's been negotiated, right? After the checks already happened,
Mhm.
or already not the checks happened, but the direct deposits
The payment's
happen.
been
That can
processed.
always create kind of a new issue.
Sure.
I don't know if you guys deal with direct deposits or whatever else, but in those positions, Sean, I'll ask you, see if you agree, but I think you're in the position of, at that point, of having to physically tender back by your own check, or probably that's the best way to do it because you want to document that for court, the eviction process.
Yeah, that's just it. Is, like Andy said, back in the day, you could just refuse a check or not deposit it or something like that and
Sure.
return it. Not so much anymore with ACH and all that
Right.
stuff.
Right.
So, as Andy pointed out, the way to handle that is to basically refund the whatever's been paid to the tenant and say that this was only a partial payment. We rejected it. The full payment is due and owing, and here's your 5-day notice, and start that process. And then they either pay the full rent or they don't, but you don't accept anything further until
Gotcha.
they
So
tender the full amount plus maybe a late fee.
would you say it'd be best or a good practice to send back that prepayment with their 5-day notice, and then everything would be certified
Yeah.
in one package?
Yeah.
I would.
Yeah. Yeah. Okay. Very cool.
Yeah, for sure. And for those watching, we're in Arizona, so this is obviously what you would do in Arizona. Landlord tenant laws, certain areas of the law, I could hazard a pretty good guess as to what the rule might be. Landlord tenant's pretty all over the place from state to state.
Definitely New Jersey, it's night and day.
Yeah.
Here is the Wild West. Like I said, you can get somebody evicted within 45 days.
Yeah,
California,
right.
New Jersey, you're looking at months.
Yeah.
And you're maybe getting them out of the property.
Yeah, you really get a broad range of some states that are very, very landlord friendly, some states that are very tenant friendly,
Sure.
and that the laws can really change. So you'd really want to consult with a lawyer
Yeah.
with regard to that. Do we have any questions?
So, not specifically for Paul, except somebody says, "Hey, I'm in Patterson, New Jersey." Paul,
I went to school in Newark. That's
oh,
awesome.
really?
Yeah.
Okay,
Yeah.
cool. Yeah.
Yeah.
So they said, "Hey, connect with them on, through Facebook or whatever, and So if you go to our feed through the Facebook group Real Estate Investor Legal or onto my Facebook page,
Okay.
you'll see our live feed and you'll see the comments, and maybe you can connect with,
That'd be
with
awesome.
another
we'll get you-
investor
That'd
online.
be
So-
awesome. That'd be great.
and there's one other question, and it was posted when we were interviewing you, so we'll talk about it. Maybe you have some insight. I doubt you do, but because I don't.
Okay.
So basically, they're saying, hey, besides being a realtor, what other hours can you count towards real estate professional status for tax purposes? So if you're a real estate professional, you can write off a bunch of stuff, I guess. So they said, well, I personally have a few rentals, and I also have a remodel company that I work 40 hours a week for.
Yeah.
So they're trying to figure out, how do I make sure that I have that real estate professional status?
Yeah, unfortunately, I don't have the answer to that. I would say to just have everything documented as much as possible, so
Yeah.
that when and if it does get to a point of an audit, you can have everything separated.
Right.
That's the best info I can give on that. I'm not sure.
Yeah, and that's really more of a CPA question.
Yeah.
So, man, it was maybe 6 months ago we had Dustin Griffiths on our show.
Yeah.
So here's the thing: we had a CPA, Dustin Griffiths, who advises a lot of real estate investors, some real high profile investors, and works with them in reducing their taxes.
Mhm.
We had him on our In-Rim show, which is every Tuesday morning at 10 a.m.
Okay.
It's on YouTube. So if you want to learn more about real estate professional status, there was a long discussion on that show regarding that. Go track down the Dustin Griffiths interview, and he'll go through and explain exactly what it takes to obtain and keep that status.
And that was In-Rim on YouTube.
In-Rib on
mornings.
YouTube
Right.
Tuesday mornings. Yep, and all the shows are there. In fact, the user says, "Yeah, I watched it." So
Awesome.
reach out to Dustin Griffiths. Set a consult with
Yeah.
me
See
if you
that
still.
can help.
Maybe
Yeah.
that's a new show. We need to
Right.
get Dustin Griffiths back on
Yeah,
and address
maybe.
that.
Yeah.
Well, hey, Paul, thanks so much for being with us. We really appreciate it. And hope you enjoyed the buy and hold meetup. It
Thank you
was
so much.
good talking with you.
You too. Thank you.
Thanks,
guys.
Paul.
Appreciate
Yep.
it.
All right. You have a good one.
You too.
All right. If you are just joining us, Andy Fowler and Sean St. Clair here. We're live from the Arizona Buy and Hold Real Estate Investor Meetup. That takes place every month at the Scottsdale Area Association of Realtors. If you're watching out of state, Scottsdale is in Arizona. This is a monthly educational opportunity as well as a marketing opportunity for those who attend. You'll find all kinds of real estate investors, hard money lenders, and other types of vendors that lawyers that come and are involved in it. It's a great way to meet folks that are in the real estate investment community and find new ways and information on what they're doing. Today, the speaker. So we come and we broadcast from 4 to 5, the beginning of the hour. But at 5 o'clock, there will be a seminar, and the topic today is how to avoid legal and title problems by using the right document and disclosures. And that's actually not the entire title; it's a pretty long title, but that is the gist of it. And you guys are talking about subject to transaction and creative finance transactions as well. Now, Sean, you're one of the speakers, right?
Yeah, I am. I'm going to be joined by Eileen Brown of American Title Service Agency, and Eileen has tons of experience closing subject to transactions. She's a escrow officer, escrow agent, branch manager. Great experience, and so we're going to just be talking the ins and outs of how to close subject to transactions and what documents you need to do it and do it right.
Man, that's such an important discussion, because as an attorney, that's, other than preparing the documents, our office does a lot of that. But on the flip side, we deal with a lot of when the documents aren't prepared correctly, or
Right.
when people just get documents on the
Yes.
internet. We've even devoted entire shows to it, right?
Right. Yes.
Yeah. So Sean will be talking about that information, as well as talking with Eileen Brown, who is a American Title Service Agency. So you're going to be able to hear it from the lawyer as well as the title agent side about making sure these documents are done properly. The disclosures have to be a big part of it, right? You guys are going
Oh.
to get into disclosures.
Huge. I mean, that's the thing with creative finance is On the back end, you have sellers who basically are going to say, "Oh, I didn't know what I was doing. I didn't know what I was signing. I didn't understand that the loans would remain. I didn't understand he would still be on my credit. I didn't understand all this." Well, if you have the right disclosures in place, they can't really make that argument because the subject to addendum, at least that I work with my clients on and prepare for them, has it over and over and over and over and over again. The loans will remain. The loans are not being paid off. The loans are going to be on your credit. Um, this is a wrap transaction. This is what a wrap means, that the loans remain in place and that the buyer has agreed to pay those loans. And if they don't pay, you have a right to foreclose. And it basically goes through and lays out everything regarding the transaction that the seller needs to know. But doesn't not only lay it out, but it requires that they go and they initial next to those disclosures, one sentence disclosures where they initial, so that if they ever went into court and said, "Oh, I didn't understand," no, look, you initialed right here. You knew what this meant. You know what this meant. You know what this meant. You know what this meant. And on top of it, I don't. We use the term subject to and sub to. Those are newer terms. I personally try not to use those because what you're doing, when you buy something subject to, you generally are doing a wrap. In the legal realm, wraps have been around forever. Judges know what wraps are. Attorneys know what wraps are. But you go to an attorney, you say, "Oh, I'm going to buy sub to." What's that? But you go to a real estate attorney, even if they don't have experience with sub to or subject to, they're going to know what a wrap is. You go and say, "Oh, I'm buying it as a wrap," or "I'm selling it as a wrap." Oh, a wrap. I get it. I've done those before. So we're going to talk about that and setting it up as a wrap and not just a straight sub to. And those, we're going to talk about those types of issues.
Now, if you're watching online, you're not going to be able to see that. So you're not going to get all that unbelievably great information. But we are going to be holding a Creative Finance Symposium next week. It's next week.
No, a week from next week.
Next week.
Yeah, a week from
because
Thursday.
we just held one last week, the first Creative Finance Symposium.
Yeah.
So you will have an opportunity, a captive opportunity, to ask both Sean and I information about creative finance transactions. And if you will, why don't you remind the listener what the topic is going to be at the Creative Finance Symposium?
Yeah. So this coming symposium's topic is everything due on sale. So we're going to basically dive into the different types of due on sale clauses and the language. I mean, a lot of times we hear this thing called due on sale. Oh, this mysterious thing, and I've never been anywhere where an instructor has dove into the language of a due on sale clause and broke it down and said, "This is how you either avoid it or violate it." And so we're going to be sampling 3 or 4, maybe 5 different due on sale clauses, because a lot of them are different. Some of them allow you to do some things and some prohibit other things, and they're all unique. And so we're going to take a deep dive into the due on sale clause. But that's not where we stop. That's just the first half of the symposium, the first half an hour. The second half an hour is open discussion with questions and answers. Anything creative finance, frankly, anything real estate. If you want to ask us about wholesale stuff, you can come on, ask us about wholesale stuff. But it's a full half an hour where we just open it up to those in attendance. That's the thing, you have to attend. That also is not online, but it's not in person either. So all you have to do is register to attend. We're going to be posting the links and different things on social media throughout the next week and a half. And you can register, you can attend in person, ask whatever question you want, and we'll do our best to provide an answer.
Yeah, so start taking notes now. Be prepared for what you want, what information you want about creative financing, and the ins and outs of the due on sale clause. With that, we have another guest who has a question for us. Welcome to the show.
Hi, thank you so much.
Yeah, what's your name? And
my name is Val Butler, and I am actually a senior transition specialist. I help seniors transition and families to decide what to do with mom and dad's home. So,
so how did you how'd you get involved with the buy and hold meetup here today?
I actually work closely with Augie Penef
Okay.
in regards to that. He is my partner in the transitioning seniors, and I also am more in towards the organizing networking events as well. That's my background before that. So I do his networking events and organize for him.
Gotcha. Well, we're here for you. What's your question?
So this is a good one, and I think it kind of fits with the topic today. And
Okay.
it may be that a lot of people out there, specifically your listeners, know the answers to this. But I'm new into the world of real estate. I'm more towards the people serving, and that's how Augie and I actually serve seniors. As I take care of the people, and he helps with the real estate. Now, this is a hypothetical question that I came across when I was meeting in different senior professionals or families. This specific family has mom is with dementia. She's in a home, community. The son is in Washington. In the meantime, somebody else has been taking care of mom for years. Mom was married for to someone that has passed. That someone buys the house with mom in 1990s. Goes through title, everything is insured, 1990s. However, that's the last time that this title or the deed of the house has been insured through a title. Everything else past that becomes a little iffy and red flagged to the point that now it's a title issue that title refuses to do anything with it until that is cleared. And the road to getting there is dad and mom get in a fight. Dad decides to quit claim deed the house to his sister to avoid any further his wife reaching for it. However, the situation is that was a family quarrel. In the meantime, sister decides to quit claim the house to her son um, because of some other family issues. So that being said, the actual owner of the house never is able to get it back. The sister and nephew live in Germany. They're the actual title owners.
Now, you said mom was on title at some point?
No,
No, she was never.
never on title. I don't even think she was, it wasn't a community property. I think it was acquired by her husband before they married.
Okay.
So during one of the fights, husband decides, oh, you're not going to get my house. Let me just quickly quit claim it to my sister. Then they get back in a marriage. And he says, oh, I want my house back. But sister says, I'm not giving you the house back. So at that point, the gentleman puts a lien on the house so that the sister doesn't purchase it. Sells it.
Sell it, yeah.
And he passes.
Oh, he
Nothing
passed away.
He passed away.
Okay.
At that point, the son of the living person that is with dementia at the moment starts a court
Probate,
proceedings,
yeah.
and he's able to get the house back in his name. The real estate attorney was served. They didn't respond. They found them, but they didn't respond. And by default is how they got the title back into mom's name.
Into mom's name or the
son, actually, because
Wait.
he was her power of attorney.
Okay, so it's back in her name. It's back in the mom. Well, what about the husband? How
He
did
passed.
he pass? But so how did the property go from the folks in Germany to the mom? Do we know?
Mom was living in there. They were the ones paying taxes. The
Oh,
folks
so
in
it-
Germany never had any
okay.
dealing with that.
So what's the problem now?
So now the deed is in the son's name, and he wants to sell it or
Yeah.
give it
Mhm.
to the person that has been taking care of mom. He's not
Okay.
interested in keeping it, but during the warranty deed or whatever, however that the deal is going to happen, title says this property is red flagged because it hasn't been insured since 1990s, and there's too many things happening in between then and now. So the question is, and I apologize for the long
Sure.
history. I hope that the listeners were able to keep up with
Yeah.
me. But the question is, how do we make this property sellable again if there is so many quitclaim deeds back then, and a lot of not really.
Yeah. So it gets really, what I would do is go back to the real estate attorney that assisted them with doing all of that
Mhm.
and work with that attorney to basically either amend or get a proper court order that does away with everything. And so you're going to have to probably go back, have more, court involvement,
Mhm.
and find out from the title company, what language do you want in this order,
Yes.
right?
Yeah.
That would make us feel good
Okay.
and allow for, that property to be insured. So it's basically, I would go back, retain the services of the real estate attorney, have put that attorney in contact with the title company, have them work together, figure out
Mhm.
exactly what
What they
they
need.
need from the court. Then that attorney goes in, gets that from the court, and that should, well, I don't know, maybe solve the problem. Hopefully.
Thank you. Thank you
Yeah.
for your
So,
time.
all right. Thanks,
Yeah.
Val. Thank you
Thank
so
you.
much.
Yeah, that was quite the fact pattern. I
Yeah.
think I'm gonna go need to get dinner after that. That was wild. Yeah. I think I would probably first thing is order like a limited title report or something. I would need to
Yeah.
re-review all of that, but that very interesting. But that happens like with real estate. I don't know what it is. I think it was with the invention of the quick claim deed, and everybody decided, well, this is pretty easy. Let's just let's just do whatever. And
How many title problems have we seen that are caused by the blasted quick claim?
the quick claim deed,
Yeah.
yeah. There was one I saw once where husband died and wife who wasn't even on title to the property just is like, well, I'm gonna quick claim it, and she came up with some weird name, and I'm like, you weren't even on the title to begin with. Much less we didn't open up a probate or do anything, and we had to go undo all of that. In any event, if you are just joining us, we are here live at the Arizona Buy and Hold Real Estate Investor Meetup. That takes place every month at the Scottsdale Area Association of Realtors. If you're new to the show, you're just finding us online. You can find us on Facebook. You can find us on YouTube as well. On YouTube, we are at InRem Podcast. You can find us at InRem Podcast. We'd appreciate it if you'd go there, like our channel, and subscribe. That helps us provide you more content. We are a legal show that provides legal information to real estate investors. That's what we do, and that's what we're here for. We're getting closer to the event, which starts at 5 o'clock. Sean, you'll be speaking. Do we have any other questions?
No, we don't have any other questions online, or from anyone here at the event. So, we're kind of to that point where we can, uh, maybe just cover a few additional things, but about the presentation tonight. But for the most part, I think in about 5 minutes, 6 minutes, I need to start getting ready for the presentation.
Yeah, Sean's going to be getting ready here. I think it's at least worth noting one more time. Sean's going to be talking about creative finance tonight, the documents needed to do it appropriately that are going to pass muster with title and aren't going to get you into any sort of problems. You, if you're watching, however, aren't going to hear any of that information. But we have a consolation prize for you. Every other Thursday in the evening, we're holding what's called the Creative Finance Symposium. It is a 1 hour event, it is a live event. It is not broadcasted live on YouTube or anything else. So you have an opportunity to come and ask questions to Sean and I and have us captive for a good 30 minutes after we present on a particular topic. So make sure to watch our channel for that. We do have another guest here live who has another question. Go ahead and put on the headphones there so you can hear
Well,
us.
actually, Andy, this is my co-presenter tonight,
yeah, you're right.
Eileen Brown. So she's going to talk with us a little bit about the presentation and tell us what we're going to be discussing tonight from an escrow perspective. Hi, Eileen. How are you? Doing well. Looking forward to the presentation tonight. It'll be a good topic, and I think I know you have a lot to offer from the escrow side. So tell us a little bit about American Title and what you do there, and kind of your niche, if you will.
I manage a branch of American Title Service Agency. We're a fairly small branch, but we do a lot of the creative stuff. And so I've been doing this a very long time. So a lot of that is because I've been doing it for a very long time. So back before loans became non-assumable, uh, without credit qualifying, it was real easy. But then, they changed those in the 80s. And so we now have learned how to do creative things to get around those kind of things. So that's kind of what my niche is to help people figure out what to do on the creative side. And of course, they're never guaranteed, but we do the best we can with the things we have and try and do them as carefully as we can and make sure to protect everybody. And that's pretty much it.
Well, my big thing is the vocabulary that's one of my pet peeves or big thing is the vocabulary that's being used right now for creative financing, and in particular subject to or sub to transactions. Everyone wants to call it a subject to or a sub to and this and that, but in reality what it is a wrap.
Exactly.
Yes,
It's exactly the same thing.
it's a wrap. And how long have you been closing wrap transactions?
40 some years.
Yeah, exactly. Exactly. But everyone wants to run around calling it a sub to and subject to, and they're like, oh, I went to this real estate attorney and they knew nothing about sub to or subject to. Well, did you ask them about a wrap? Okay,
yeah.
no, like they would probably know what a wrap is, but
Exactly.
yes,
It's the same concept.
Right.
It's just really, it's where you're not paying off the seller's loan. You're not replacing it with your own financing. You're leaving it there and you're promising to make the payments.
right.
So same thing as a wrap.
Yeah.
It's exactly the same.
And frankly, I personally am of the opinion that it any type of subject to transaction outside of, say, an agreement for sale or lease with option or whatever, but a straight, with a warranty deed, you're conveying title, and you're going to leave those existing loans in place. I personally believe that it should be a wrap. I think that you should give the seller a performance note,
Absolutely.
a deed of trust.
That's correct.
Yeah, none of this performance deed, deed in
I
lieu,
will
anything
not
like
do
that.
those.
Yes, I'm
I
with
won't do-
you.
And I won't do what they call a subject to transaction without doing a performance note and deed of trust
Right.
and set up
Yes.
servicing for it. It's just not safe.
Yeah.
It's unfair. It's unethical as far as I'm concerned. And so we just don't do them that way.
Right.
We don't do that kind of business. And so anybody who wants to just do those without doing those protections, for all the parties, not just for their own selfish needs, but, for everybody's
Right.
good sake. And you get a lot more quality of life out of it if you do them the right way. And so,
Right.
yeah, we will absolutely not close one without doing performance note and deed of trust. And we will not prepare performance deeds or deeds in lieu of foreclosure because they're really not valid. The statutes in Arizona require that a buyer and seller has to sign that deed of their own free will.
Mhm.
It may be your own free will today, but 2 years down the road, when you have a financial difficulty, it may not be.
Right.
And if that gets challenged in court,
Yes.
it's going to go bye-bye. It's not
Yeah.
going to be enforceable.
Right. Because
So-
you're doing an in run around our statutes that give certain time frames,
Exactly.
that type of thing. And
Just do it
yes.
the right way.
Yes.
2 years if something happens, then great.
Right.
Then come see me and we'll do a deed in lieu of foreclosure
Right.
with the proper estoppels. And that's the thing too, that a lot of
Yes.
those performance deeds that they're promoting nowadays don't have that estoppel language in them.
Yeah.
And so it doesn't perform the same function.
Well, and the other thing that, investors, buyers don't realize when they say, oh, well, seller here, you can have this deed in lieu of foreclosure. And if I don't perform, go and record it. What the seller doesn't appreciate, and I don't even think the buyer appreciates this, is let's say 2 years down the road, the buyer stops paying, so they don't perform. Seller goes and records that deed in lieu of foreclosure. But lo and behold, the buyer has taken out additional financing. Lo and behold, there's mechanics liens. Lo and behold, there's all these other issues.
Judgments, tax
Yes.
liens,
You-
all sorts of things.
Right.
Yeah.
The seller then takes it subject to those items versus
Yep.
if they just go through the 90-day foreclosure process, they wipe it all out.
That's right. That's
Yeah.
right. Anything subsequent to that original document, the performance note and deed of trust, gets wiped out by a trustee sale.
Right.
The
Yes.
foreclosure action takes care of it. So there's no risk to the seller. It takes, okay, so it's 121 days. Big deal.
Right.
It's
Yes.
a lot worth it.
Well, tell us a little bit about, you and I are presenting tonight. Tell us a little bit about, obviously it's kind of, I think, a panel question and answer, but,
Mhm.
what are you talking about from an escrow perspective tonight, or do you hope to talk about?
Probably things like, how to handle insurance properly on the wrap transactions and
Yeah.
things like that. It has to be handled very delicately because once the seller deeds the property out, his insurance is not gonna pay any claims. So,
Yes.
but if the seller cancels his insurance, the lender has two choices. Number one, it's gonna be their red flag that something's happened. They're either gonna put a forced place coverage insurance on it, which is like $4,500 a year or
Mm.
more, and increase your payments a huge amount, or they're gonna get a notice that it's sold and they could enforce their due on sale clause.
Yeah.
And there is more of the due on sale clauses being enforced now than there have been in the past. I mean, I've probably done thousands of wraps, both personally and professionally.
Uh,
I've seen one get called.
yes. Right.
So, it's not that likely, but that one actually was because of an assistant that I had in the 90s.
What'd they do?
So they sent a settlement statement with the check to catch up the back payments.
Oh.
And so the lender said, we're going to call this loan due and payable. And because it was our fault, the title
Yeah.
company that I worked for had to cover the expenses for that buyer to get a new loan with like terms. That wrap was. Now, luckily, it wasn't horrible, but it
Yeah.
was still $8,000 in the 90s was a good chunk of change.
Yeah.
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 And
For
so
sure.
that was a lesson well learned. Now I get to
Right.
be more of a control freak.
Well, what is your thought, or what advice have you received from maybe attorneys regarding insurance? I personally have an opinion, but I'm curious always what's out there. What have you
The way
on
I
structuring
the
it?
way I've always done it when I'm doing it myself,
Yes.
especially, I have the seller change his policy to a fire and extended coverage with a $2,500 deductible, as much as I can get away with for the lender. And then I put my own policy on it.
Yeah.
And I
Okay.
name the seller as the lost payee, not his lender. So
Yeah.
his lender is never notified that I have insurance on that
Oh,
property.
interesting.
So
Yeah.
yes, there's two policies, but one of them's never going to be able to be used. It won't be honored.
Yeah.
Period. So that's how I do it.
Interesting. Yeah, there's a number of ways to structure it.
Mhm.
There's an attorney, Alan Sesker out of Texas,
Mhm.
who is, in my opinion, one of the leading experts on wraps. And I had a chance to attend his in person in Dallas, his Wrap University. And so his take on it, but he has an insurance agent that's also an investor and buys, creatively.
Yeah, if you
And
could get
so
lucky, that's what you want.
yes. So this insurance agent had a chance to speak, and Alan spoke, and their take on it is that you what you do is the buyer obtains their own insurance, like you said,
Mhm.
and names the seller as an additional interest
Mhm.
under the policy,
Mhm.
names the original lender as the lost payee, and then the seller cancels and they submit that paperwork to the lender. And they've not had the lender call based upon them doing
Mhm.
that. But once again, you have an insurance agent that
That
understands
understands it.
it, knows how to follow up with
Yeah.
the, insurance department at the lender and say the right things
Right.
and make sure that it avoids
Exactly.
forced place coverage and all of that. So,
Yeah. That
um,
would be like a 1 in a million insurance agents.
Yeah.
We used to in the, early days of wraps, we used to add the buyer as an additional insured, especially when we were using an agreement for sale, because the seller still retained fee title interest
right,
and transferred only equitable title interest. So because of that, then that policy would still be usable
right.
because he still has an ownership interest in the property. So we used to be able to do that, but I haven't been able to get an insurance company to do that since the late 90s.
Yeah.
Well, Sean and Eileen, I know you both got to get in there, and you got people waiting on you. So let's get to it.
Okay.
We know that we appreciate Eileen coming by and saying hi, and looking forward to the presentation. With that, if you're watching us here remotely, remember that we're live every Tuesday at 10 a.m. Arizona time. And again, watch out for the Creative Finance Symposium. With that, see you guys next time.
Yeah. Have a
All
good
right.
evening, everyone.
Thanks, everybody.
So